what's interesting about military law, about veterans law, veterans and service members in general is we pretty much touch just about every aspect of law there is. So if you're there saying, hey, I'm labor and employment, how does this affect me? There's you, Sarah. If I'm a family matrimonial attorney, how does it affect me? Well, survivor benefit plan, which is one of the things we're going to get into, is going to be another way that it affects you. If I'm a criminal attorney, how does that affect me? Titling, which we'll talk about today, Veterans Treatment Court. So it's going to be able to reach out and touch just about every area of law for those who are service members and veterans. Name's Chad Lennon, work in the military, security clearance, federal employment areas. I'm also a major in the Marine Corps Reserves. Next slide, please. So this is our agenda. SBP is a survivor benefit plan. The FY23 NDAA, National Defense Authorization Act, created an open enrollment. We'll also talk about the COVID vaccine mandate being terminated, some other areas of military justice. We'll get into titling, a little bit of Inspector General, and then other little bit of items that popped up during the FY23 NDAA. Really the biggest things that are going to affect attorneys is SBP, COVID, and titling. Those are the three main areas I would say that had the most impact. So the National Defense Authorization Act comes out every year, usually around December, and it pretty much puts out not just the budgeting, but different actions that are going to be taken when it comes to the Department of Defense and the uniformed services. So there could be a major impact into somebody's life, like survivor benefit. It could be a major impact into a specific area, like shutting a base down. So that's where the National Defense Authorization Act comes in. And again, it's every year that this comes out. It's thousands and thousands of pages. You can look through it. There is a type of index at the beginning to try to find what could be relevant to whatever it is you're interested in. So for military justice, might need to come through it a little bit more because there are things that can touch various aspects throughout the thousands of pages. So let's get started. The next slide, we're going to talk about survivor benefit plan and the open enrollment. So what is a survivor benefit plan? It's financial support to spouses and or children when a service member dies while on duty or after retirement. And for our purposes, we generally see this after retirement. It's a monthly payment known as an annuity. And what happens is when a service member is retiring, whether they were active duty or reservist, they should be told about the survivor benefit plan. It doesn't always happen. And even when they go speak to somebody about this, they may receive the wrong information. So if I am a married service member, I'm retiring, what I want to do is decide, do I want this survivor benefit plan? It's pretty much saying if I die, then my spouse will get payments after my death to help financially support my spouse after my death. I can turn this down, and I can also not give 100% to my spouse. However, there is going to be notification given to the spouse that either they were not enrolled in survivor benefit or they're not receiving 100%. Children can receive SBP. Businesses can receive it as well. It's very rare for that to happen. But what you see is out of the retirement pay that retired service member receives, some money is taken out to help fund the survivor benefit plan. And again, once that service member passes away, the surviving spouse, possibly a former spouse, the child, whoever it may be, can receive the benefits. So the spouse must also agree to either receive or not receive the maximum. And it becomes very difficult to change. It's pretty much once you're locked in, you're locked in. The only time that anything can really change with who is going to be the benefit or beneficiary of SBP is a major life change, such as a divorce or open enrollment. Now, this open enrollment, I think it was maybe 10 years prior that they had open enrollment with survivor benefit plans. So you could see how rarely this happens. DFAS, Defense Finance Accounting Service, is very black and white. You either enrolled or you did not enroll. So if you're talking about a service member who is married at the time and then they become divorced, you can go through the courts and have your divorce settled. And in there, the judge could say that the former spouse is going to continue to receive the survivor benefit plan or that they're not going to receive it. What happens is there has to be a period of up to 1 year for the service member or the spouse to notify DFAS of what occurred and who's going to be receiving the benefits. Now, as a service member, you're probably more, or a veteran, that individual is probably more aware of what I have to do to notify DFAS of the change. The spouse may not be as up to date with what the process is, thinking, hey, the court gave us our divorce decree, it's in there, no need to worry about it. It's the same thing with the matrimonial attorney thinking, oh, it's in the divorce decree, there should be no issue. This is where an attorney that you can get in trouble because you are supposed to be aware of what you need to do to enroll. You have to notify DFAS that something has changed. You have to notify that you want the survivor benefit plan. This whole process has to take place. And as the attorney, if you don't make or you don't file a deemed election, you could be on the hook for that. It's within 1 year of the divorce or order granting a former spouse survivor benefit plan. It puts DFAS on notice that the former spouse will be the beneficiary. Now, without that deemed election, the former spouse will not be paid by DFAS as the beneficiary. Some issues we've seen is that the service member or veteran is making the payments to the survivor benefit plan, and once that service member passes away, the former spouse seeks to receive the benefit and is denied by DFAS. So this is, again, where we can step in and petition to DFAS, potentially petition to the Board of Corrections for military or naval records that an error was made. The problem is, as I stated before, DFAS is very black and white. And for DFAS to admit to an error, that's good luck with that. They're pretty much just going to say, nope, everything was done correctly. You can go and appeal to Doha, but you're probably going to end up having to go to the Board of Corrections for military or naval records. There's more or a better chance of succeeding in your case going to the board, I would say, than through DFAS. We've even seen where constructive deemed election, what our argument was still denied. So there very much, you have to go through everything required, all the forms, everything must be done timely. We've even seen cases where when a service member who retires is single, and as a retired service member, retired veteran, they go and get married, and then they want to go speak about, how do I go about enrolling in the survivor benefit plan? That individual, in a case that I have, was told the wrong information about the timeline. So we make the argument that as an agent of DFAS, an agent of the government, the information given was incorrect and harmed that individual. Where do you go for that? You go to DFAS, Doha, you go to the Board of Corrections. But now we have this open enrollment. So we can see where a lot of things get into issues here. And we also see issues of a service member is married, enrolls in survivor benefit plan, makes the deemed election, and eventually they're divorced, and then they get remarried. So you can see the further issues. The big thing to remember as a matrimonial attorney is that if the divorce decree discusses survivor benefit plan, must make sure that a deemed election is made within 1 year of the divorce to DFAS. That is your responsibility as the attorney. When we have open enrollment, right now, if you go onto the website for Defense Finance and Accounting Service, there is open season right now, and this began with the NDAA. It is open for the entire year. Now, it took DFAS a few months to even open anything, and it took even more to open up two ways to enroll. The first was you can disenroll from the survivor benefit plan. That was the first portion that they opened for the open enrollment, which is, I'm a retired service member, I don't want survivor benefit plan anymore, so I'm going to disenroll from this program. The forms and the process to go about disenrollment are on the website. If you go to dfas.mil, retired military, you'll see the NDAA 2023 Survivor Benefit Plan open season. Now, what happens is, as we discussed, when you are retired and you enroll in survivor benefit, you have to make payments uh, for that benefit. And when you disenroll, you do not receive any of the money back. So all those payments made have already been made, and that's it. We're done. The other one that's just opened up recently is the open season to enroll. And this is for service members to enroll in survivor benefit plan or enroll somebody into it. The process is here on the website. It talks about 4 steps that need to be made to enroll, a letter of intent to enroll. There's other different forms that you'll see with the government all the time that you have to fill out. They'll need marriage certificates or birth certificates for children, divorce decrees, all that relevant information to either enroll a spouse, a former spouse, children, whatever the case may be. Now, when you're enrolling in survivor benefit plan, you have to make the premium payments, and it goes back to the first day somebody would have been eligible for this program. So you could enroll and say, such as when you go to the boards, oh, my client should have been enrolled 3 years ago in this program. And if the board says, yes, you are correct, that's what should have happened. What then happens is DFAS is going to come knocking on the door going, hey, you owe us 3 years of premiums from the first day that that beneficiary would have been eligible for the program. Now, that is a amount of money that you're going to have to pay back. Again, you can make arguments to the board saying, they were never covered. It's unjust. But essentially, this is the position that DFAS and the board usually takes, is you have to pay back all the way to the first day you're eligible for those premium payments. This can be a good program if you know what you're doing. It's something that if you're going to talk to a service member or a veteran, how is your financial situation? And everyone's is different. Is this beneficial to your situation? Maybe not everyone needs to enroll in survivor benefit plan. So that's what you want to take a look at, the individuals, take a look at what your client situation is, and determine, is this something we want to move forward with, possibly discontinuing the program or possibly enrolling in the program. All right, so with that, we're going to go to our next slide. The COVID vaccine mandate. So many of us in the military practice group, federal employment, state employment, we saw the news with the issues going on with COVID and the vaccine, that it was mandated that everybody in the DoD, this included contractors, had to receive the COVID vaccine by a certain date. In the military, there is religious accommodation requests, there is a medical accommodation request, and individuals can make a request to not receive any type of vaccine, whether, forget about COVID, but the flu or anything else, because of religious reasons, for issues of possibly being allergic to one of the ingredients, possibly having adverse effect to a previous vaccine of, say, the flu. Flu is the most common one because every year service members are supposed to receive the flu vaccine. So we'll use that as our other hypothetical. So if I got a flu shot 2 years ago and I had an adverse reaction to it, whatever that was, I can then put into the military saying, I believe I should receive an accommodation medically to not receive the vaccine. Now what we saw is service members were receiving these accommodations. Some had permanent, some had temporary. It's also what you see with vaccines is, where is the service member going to be deployed to? When you go to outside the country to certain areas, you are sometimes recommended to get specific vaccines for the area you're going to. So again, you would see accommodation requests put in, and a lot of these were approved. Now, when we saw COVID come around and the vaccine, one of the issues was it has to be FDA approved. Years ago, we saw under emergency authorization, they tried to make the military service members take the vaccine. Case went to the Supreme Court and essentially said, you can't have service members being guinea pigs. That has to be FDA approved. So nothing was done until the FDA approved the first COVID vaccines. So there was a certain amount of time once the notifications went out across the different branches via the SecDev, Secretary of Defense, and said, okay, everyone needs to receive their vaccine by this time frame. That's when we started to see service members put in accommodation requests, whether it was religious, whether it was medical. And then we started seeing that And then usually it was 30 or 60 days, if I remember correctly, that once you put these accommodations in, there had to be a response made, depending on if you were CONUS inside the continental United States or OCONUS outside the continental United States, that you would receive a response. However, that timeline was completely blown through. There was thousands and thousands of requests made, and it took months, months and months and months to get anything back. Once we started receiving the responses back, there were pretty much boilerplate denials where, depending on the service, everyone got the same letter, changed the name, changed the unit. They talked about military readiness being an issue with this. However, when we looked at, because you also had the process to appeal, every service member had the right to appeal the initial denial. And we did many appeals. And some of the arguments were, if you look at the numbers, and the DoD put these numbers out, I think it was just under 100 service members died from COVID, while thousands and thousands were becoming separated from the military for not taking the vaccine. There was very few that the accommodations were approved. Those were mostly those on terminal leave. What that means is the end of their contract was coming up and they had so much vacation time that they could take, they had 90 days. If they're 90 days out from their separation period, they can go on leave for 90 days, do their entire checkout and be done. Now they'd still be under UCMJ authority until their actual separation date, but for all intents and purposes, they were separated. Those were the only individuals who were really receiving the approvals for the accommodation. So again, we see the appeals go in, and we saw again boilerplate denials. Each branch pretty much had the same exact letter. You just change the name, change the unit, everyone's denied. So once somebody was denied, now not everybody who was denied on the initial accommodation request put in an appeal. So those who did not are in a separate category. Those who put in for a appeal, that's another category. What we also saw is there was class action suits ongoing. And just about every branch, except for, I believe, the Army, until the mandate was terminated, had class actions that stated the military cannot take disciplinary actions against those who were seeking religious medical accommodations and did not receive the vaccine. So everything was at a standstill. All of a sudden, we found out on the FY23 NDAA is that they terminated the COVID vaccine mandate. Now, there's a lot of thoughts of why this happened. The manning numbers drastically dropped in the military. I think the Army was 25% below recruiting at the time. So the Secretary of Defense had to rescind the mandate that service members would be separated from the armed forces if they did not take the vaccine, and the vaccine would just go away. Now, when we saw one case in federal court months and months earlier, where it said you can't force the vaccine on the service members, everything stopped. So if there was somebody in the process of being administratively separated, that stopped. If someone was in the process of seeking an accommodation request, that stopped. Here we saw it was just terminated. So everything immediately ended. What was supposed to happen too is that any disciplinary paperwork, negative disciplinary paperwork about a service member who did not take the vaccine was supposed to be removed from the record. Now, is that actually happening? I can't imagine it is really happening, because there are thousands and thousands of service members, and you've seen individuals who had negative observation reports, fitness reports, though besides those that were separated, those who are receiving memorandums of reprimand, counseling, 6105s, all this official paperwork that goes in the record has to be removed. Is there enough manpower? Is that a priority to remove that? I highly doubt it. So you're probably going to have to see something go through the Board of Corrections to remove the negative paperwork in the records of service members who were seeking accommodations who did not take the vaccine. There was no real guidance for those separated, except either they should receive a general or honorable discharge. Now, I believe there was a few who received OTH other than honorable. When you look at discharges in the military, the highest you get, the best you can get is honorable. That's what everybody looks for. There's a general discharge under honorable conditions. It's not as good as honorable. The thing that you lose when you get general is your education benefits. Then you go to other than honorable, and that just doesn't look good on your record. So the FY23 NDAA stated the guidance for those separated is receive a general discharge or honorable. It's supposed to automatically happen. That was the intent. However, is that actually happening? I don't know. But again, you may need to look at having a discharge upgrade petition to the board. When it comes to contractors in the DoD, the requirement was temporarily suspended. Now, where do we go from here? Right now, we see the FY24 NDAA is being drafted. One of the things I just found out this past weekend they're looking at is reinstating service members that were separated from the military for this issue. And the separation would the reinstatement would put the service member back in the same rank that they were in when they were separated. There's no clarification that I've seen so far. Let's say someone is at the rank of E4 and that command wanted to drop them to an E1. Will they receive that previous rank? How's that process? That hasn't been flushed out. But right now, some of the highlights I've seen is they're looking at reinstating service members who were separated. What they're going to do at that time frame is say it's almost like taking leave without pay. It's just a temporary removal, and it's looked at to not negatively affect anyone who's looking at promotion, because in the military you have service limitations. You can only be in for a certain amount of years at a certain rank. So if you're an E4, you can't be an E4 for 20 years. You have to be able to promote to E5. So the intent we're looking at right now, based on the notes and the highlights I've seen, is that they don't want this separation from the military, that time frame, to affect a potential promotion. So it's important to keep an eye out in the next few months. Will the NDAA for FY24 be signed, allowing reinstatement to those who have been separated? The other issue we've seen with this vaccine mandate being terminated, I've got one case that really highlights the issues. So when someone is being separated from the military, they may be on leave pending separation. I have a Marine right now who is in that case, outstanding Marine, meritoriously promoted throughout his enlistment. He was one of the top performing officers and was career designated, which is a big deal for Marine officers. Outstanding fitness reports, constantly at the top. So he puts in for the vaccine accommodation, and it's denied. He never put in an appeal. That's what hurt his case when it comes to some of the other issues that we've seen. However, once the termination of the vaccine mandate came, he was still pending leave. So he was not separated. However, it had been months and months that he was pending leave, waiting for the paperwork to be finished to separate him. He moved his family. He began his wife began working. He went home and became the stay-at-home dad, was homeschooling the kids. His wife had this job, and they completely changed their life. Guess what happens? He's now getting orders to go back on active duty. We're in the process of fighting this, trying to get him in early retirement, everything else. But there are the cases of those individuals who fell between the cracks of pending leave, pending separation, moved on with their life, and now stuck with, they may be forced to take orders and face other types of disciplinary administrative action if they don't. We'll see what happens with that case, but that's just one example. All right, we're going to go to the next slide here. Just general military justice, additional covered offenses, the Office of Special Trial Counsels, amending the manual for courts martials, the specific offenses to transfer it to an appropriate entity. We're talking a lot about what's changed when it comes to sexual harassment, sexual assault. That's been one of the big highlights that some politicians want to look at, saying there's a huge issue in the military with this. Military assaults, military sexual assaults, military sexual harassments. But you can see here, it's just a couple amendments. Article 66, authorized judicial review for any conviction by court-martial. Article 69, clarify the scope of review for general and special court-martials reviewed by the JAG. And Article 25, randomized selection of personnel for service as panel members on a court-martial. Those are just a lot of procedural things. I don't see this really affecting the civilians working in military law, except when we're looking at court martials. what's the difference between general and special court marshals? It's the rank, it's the scope of authority. Don't want to get too much in the weeds, especially for those who aren't really deep into the practicing military law, but it's just really who has authority and what those court marshals can actually do. Let's go to the next slide. Oh, all right, so we got the course code. That is 191307. Say again, the course code is 191307. I'll keep that up for about 30 more seconds. All right, I go fast, so I'm going to say that's 30 seconds. Let's go to the next slide. All right, titling. Unless you worked in military law, you probably have no idea what titling is. In fact, service members probably have no idea what titling is. This is when a service member who is subject of an investigation through their CID, OSI, that the investigation division of the military looks into a crime and says there is credible evidence that the service member committed this action. The standard is credible evidence. Now, what exactly is credible evidence? Well, it really depends on whoever's investigating the case. It is so subjective that an allegation by itself may say to the agent, it's good enough to be titled. The member cannot be removed if this is the updates, cannot be removed if it endangers a witness or victim, discloses intelligence, compromises ongoing investigations. It's very generalized, there's no specifics. So let's go back to titling. It is under the DOD instructions that during an investigation, that if it is considered credible evidence, credible information disclosed or obtained by an investigator, that considers the source and nature of the information and the totality of the circumstances, there is sufficiently to believe that a trained criminal investigator presumes the facts in question are true. Again, very general, not a lot of specifics here. This is where we get into issues. And here's the other thing too, is that until recently, there was no notification ever needed to tell a service member they were titled. Now you're thinking, well, what does this mean? FBI background check, titling shows up. Now, if you don't know what you're looking at, which most people don't when they look at the FBI background check and a titling pops up, you think an FBI background check goes, oh, this is everything somebody was convicted of. Well, no, there is no conviction needed to be titled. Again, it's not probable cause. It's not clear and convincing evidence. It's not beyond a shadow of a doubt. It's credible evidence. Even when a service member is found not guilty at court-martial, does not go to court-martial, goes to an NJP, only receives a counseling, titling can still show up. What you're supposed to, let's go back a little bit. So credible evidence, offering reasonable grounds for being believed. Again, it does not mean there's evidence to corroborate what an allegation is. It is just the agent, that a criminal investigator for the militaries, whether it's Army CID, NCIS for the Navy and the Marine Corps, CGIS for the Coast Guard, OSI for the Air Force, it is that investigator who says, I think there's credible evidence that this service member committed this crime, and they're titled. Again, it pops up on the FBI background check. If you look at it real quickly, you don't understand what you're looking at, because it could even say, disposition counseling received. So to those of us in the military who've been in the military, oh, a counseling statement, I know what that is. I can receive a counseling statement because I was late to work today. All right, I can receive a counseling statement because I did such a great thing during training. Or I can receive a counseling statement because I was accused of a crime, assault, or whatever else the case may be. So we've seen cases where I'm working on a case right now. Service member is accused of sexual abusive contact. The joint investigation between the local police department and Army CID. The local police department says there's no probable cause. We're not moving forward with anything we're done with this case. Army CID says, we think there's probable cause, and we're going to turn this case over to the command. Not turn the case over for a court-martial. So the command goes, all right, service member, we're going to do a NJP, non-judicial punishment. In the Army, it's Article 15. It's where it's essentially a kangaroo court where a service member goes in front of their commander. Now, the commander could be a supply officer, could be a pilot, could be infantry, and there's no need for you to have any legal or investigative training. And the commander says, all right, I'm accusing you of committing this violation of Article 120A. All right, what do you have to show that you didn't do it? Well, here is evidence that I have from the investigation. Here is witnesses, here's witness statements, character statements. And even if the service member supplies all that, the commander can still go, no, I still find you guilty on NJP. And then the NJP shows up on the FBI background check. Now let's go back. Let's say the service member says, no, I don't want NJP or Article 15. I want to go to court-martial. That's what happened on the case I'm working on now. Army never went forward with the court-martial. All he received was a memorandum of reprimand, and this individual has been titled. Never went through a court-martial, never actually NJP'd or Article 15, only received a memo of reprimand, and he's titled. So what we do is we look at what is the standard, and it's under DODI 5505.7. That's the instruction you want to look at for titling. You go through that, make your argument. Now, what happened in FY21, we see guidance to agencies about removing titling actions. What they say is that the information should be corrected, expunged, or removed from the criminal records and databases if probable cause did not or does not exist to believe that the offense for which the person's name was placed, reported, or maintained, and there's insufficient evidence existed or exists now to determine whether or not the offense occurred. So probable cause did or did not exist to believe the person actually committed the offense. So it's saying one way to argue is at the time of the titling or today, there is a probable cause to believe that this did not happen. That individual's titling action should be removed. This is important for criminal defense attorneys because when you go to court and look at an FBI background check, a criminal background check, these titling actions may show up. We've had clients who've gone for jobs with government jobs. They do a background check. It shows up and they lose their job, even though they have no idea that this took place. When looking at the new law under FY21 NDAA said to consider other factors, the extent or lack of corroborating evidence against the person, whether adverse administrative, disciplinary, judicial, or other actions was initiated, and the type, nature, or outcome of any action against that person. So there's further guidance in the FY21 NDAA. Those are important factors to look at. And lastly, we look at what was the update for FY23. It says that individual cannot be removed for 3 reasons: endangering a witness or victim, disclosing intelligence, compromising an ongoing investigation. I think this is rarely anybody would fall into this, especially for those who've never been found guilty at a court-martial or found guilty at an NJP when there's, I would say, clear and convincing evidence that it was the wrong outcome. Again, many times on an NJP Article 15, the commander's already made up their mind. The other thing to think about is an NJP in Article 15 someone can be found guilty, but that can be suspended for, let's say, 6 months, almost like just stay out of trouble for 6 months, it goes away. So endangering a witness or victim, disclosing intelligence, very rarely will we see anything like that. Compromising an ongoing investigation. Usually what you'll see when you request the records from CID, you want to look for the case was closed without any other action. That's a big piece to put into a petition to say it's just not going to compromise any other ongoing investigation. That's titling. I think this is a major issue in the military. I haven't seen anything for FY24 considering titling. I'm trying to look into that a little bit further, but there's been thoughts of maybe we need to upgrade this from credible evidence to probable cause. I think we still need to do a little better than that because this is titling adversely affects somebody's future. A service member or a veteran can have an honorable discharge and still be titled. I have another case of a service member who popped on a urinalysis for marijuana. OSI looked into them, titled them for marijuana, had no idea she was titled, went to get a job in the schools, and was denied because something came up in her FBI background check. Now, for that case, we can look at an argument of, hey, Biden just put something out if anyone who was simple possession of marijuana is getting cleared for anything in their record. But again, we see honorable discharges, yet some folks are still titled adversely affecting their future. What you want to do is petition that CID, NCIS, Army CID, CGIS, OSI, and give your argument why the titling should be removed. Just about every time they're going to deny it, then you're going to have to go to the Board of Corrections for military and naval records. And again, it takes 1 to 2 years, if not longer sometimes, for a decision to be made. All right, let's go to the next slide. Mandatory IG investigations in Inspector General. So the Inspector General depends on your interactions with them, but Inspector General sometimes have fugazi investigations. Now, when it comes to the issues of sexual assault, sexual harassment, and domestic violence, again, this is a major issue, political issue in the military right now. Inspector General is about fraud, waste, and abuse. If there is an allegation of a violation of policy regarding investigations, processing, treatments of reports of sexual assault, sexual harassment, domestic violence does not include a complaint alleging an act. You may withdraw the complaint if the complaint is referred to the chain of command in 10 days. So somebody can make a complaint and then within 10 days, remove that complaint and nothing will happen at that point. Do we really see a lot of this ongoing in our cases right now? I haven't seen that myself. I haven't heard much about this being in effect, but it allows somebody to withdraw a complaint within 10 days and ensure that no unnecessary actions are taken against one of the service members. All right, and let's go to the next slide. Miscellaneous items, authorizes service members whose sole dependent dies to continue to receive basic allowance housing, BAH, with dependents for up to 1 year from the death of a service member or the death of a dependent. This is really just to make sure that the service members aren't severely financially harmed in any manner when a dependent passes away. It's a period of 1 year to adjust. This might affect somebody, say, in a tax realm, but this is something that is beneficial to the service members to help to adjust to a new life. If a service member loses a dependent, especially a spouse, you could look at something along the lines of a hardship resignation, a hardship separation from the military earlier than what their contractual time says. Other thing we saw was a 4.6% raise, which is the highest in the last 20 years for service members. And we also saw a cold case unit established in the Army. This is really more a procedural thing. You had cold case units already with NCIS and the OSI, and they just formally established one in the Army. What the Armed Forces committees are now looking at, marijuana. So what changes will come to marijuana-based offenses? There could be a change to those who were discharged based on marijuana. And we saw that a little bit. You saw the pardon that Biden gave to anyone with simple possessions of marijuana. You can see the changes happening across the states with legalization, decriminalization, marijuana dispensaries. And here's another thing that we see. When you have those service members who are popping on a urinalysis, a lot of them will pop for THC or marijuana and have no idea. But then you start talking to that individual a little bit more, you learn that they vape. They maybe use somebody else's vape pen. Well, that other person may have used marijuana. Now the service member uses someone else's vape pen that had marijuana in it, and they pop on the urinalysis. The other thing is you have gummies and other types of what's called food that has marijuana in it or THC in it. There was a big issue that happened a few years ago, CBD. CBD is not marijuana. CBD can be used as an oil to help calm people, to help heal injuries. However, there is no requirement, it's not FDA approved, there's no requirement to say if there is or is not marijuana or THC in CBD. DoD noticed that a lot of individuals were popping for THC who use CBD. That's why CBD is not authorized for service members. There is something that just came out on a MAR admin, some Marine side, Marine administrative information sent out about poppy seeds, because now you're seeing service members pop on a urinalysis who are eating poppy. The big thing to remember is that I believe it is 15 nanograms per milliliter is the threshold to pop positive in the military, while generally civilians, it's 50 nanograms per milliliter. So it's a much lower threshold. And again, going back to we're seeing the decriminalization, marijuana cards, there was a huge issue when Colorado first became the first state to legalize marijuana, where service members were popping and they go, well, it's legal in the state. Well, it's not legal with the military. Just because there may be something legal in the state or federally legal or not illegal according to the federal law or the state law, the DoD may say you are not allowed to take this, such as CBD. So it'll be interesting to see what comes out with the next year's NDAA. Again, I haven't heard or seen anything about that thus far, and it could be another 2 years with that where they're still looking into it. I believe it is still a class 1 drug. They think there's no medical use behind it. I could be wrong on that, but we're looking at maybe the military will seek medicinal purposes. We don't know. Again, this could be something that's going to change, and it's going to affect discharges, because anyone who was discharged for popping for marijuana, they could see their discharge upgraded. Besides looking at a discharge upgrade through the DoD, you could receive a discharge upgrade through the VA for VA benefits only. You could see discharge upgrade through the state for state benefits only. Right now in New York, as a couple of years ago, they have the restoration of justice, restoration of honor, where service members can seek a discharge upgrade for the purposes of New York State benefits. So it'd be interesting to see what's going to come out of the reviews of marijuana-based offenses, discharges on marijuana, with the NDAA as it comes out in the next year or two, or maybe even further after that. So let's go to the next slide. All right, so as we've covered a few different topics here with survivor benefit plan, the COVID vaccine mandate being terminated, military justice, titling, inspector general investigations, and a couple other items. Again, the big thing I want to talk about that I want you to remember is the survivor benefit plan and open enrollment. It is open until the end of this calendar year. They haven't been opened for, I think it was 10 years prior to this year. So it is extremely rare for this enrollment period to open. The vaccine mandate terminated. And again, we're looking at potentially having service members reinstated with the next year's FY24 NDAA. And the other big one we talked about was titling. Those are the three ones we need to remember. Titling, again, for those criminal attorneys. When you look at your, if you have a veteran as a client, you want to get the FBI background check and look into, was my client titled? And you want to get clarification on that, because the judge and the prosecutor may be looking at that and going, oh, look at everything they did while they were in service. It's not as simple as that. So right now, I just want to open it up if there's any questions, any comments, any concerns about what we went over.
If there are any questions, please submit those in the chat so I can send those over to Chad so he can answer them. We'll give everybody a minute or two just to get those submitted.
And on the last slide here, you'll see this is my contact info, or the contact info in New York. My email is clennon@fedattorney.com. If you have questions, please feel free to reach out to me. And I'm expecting us to do another one of these next year with the FY24 NDAA comes out around December. Again, it's thousands of pages, but looking through the highlights, looking through that, I'm sure there's going to be some information that will affect military justice, especially for civilian military law attorneys.
So the second course code is going to be 413278. Again, the second course code is going to be 413278.
All right, so again, I think everybody got the slides. They're just highlights of everything. If you have questions, please feel free to reach out to me. If you're not one of the attorneys at Tully Rinckey, feel free to reach out any of us at Tully Rinckey in the Military Law Practice Group. We'll be happy to assist with any issues ongoing that were related to the changes and the updates in the FY23 NDAA, and we'll be looking forward to see what the FY24 NDAA has for us next year.
Thank you everyone again for joining today's presentation, and thank you Chad for presenting. Please ensure that you complete and return your course evaluation and an affirmation to cle@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you.
Thank you, everyone.